Yes, hello. Hi. How is everyone? Hello, everybody. Broadcasting. Coming to you live from the University of Utah's J. Cooney School of Law. I've been studying to show myself approved before. The rock outside tells it all. If you can't tell by looking at the wall behind me and all the gold and black lettering on the books, here's what I have for you. Doing study and research writing. I yearn to read. I'm learning a lot. If you can already believe it, it's dusk and I'm still after school. Programming, more or less, I guess you could say, in a manner of speaking. Anyways, checking the email, checking the email. I'm scrolling up high, I'm scrolling up low. I'm always late for school because your mom drives slow. Ooh. Alright. Well, let's get right to it. A writ of Corum Nobis. The writ of Corum Nobis, also known as the writ of Corum Nobis, writ of error, writ of Corum Vobis, or writ of error Corum Vobis, is a legal order allowing the court to correct its original judgment upon discovery of a fundamental error that did not appear in the records of the original judgment's proceedings and would have prevented the judgment from being pronounced. The term Corum Nobis is Latin for before us, and the meaning of its full form, quae coram nobis resident, is, quote, which things remain in our presence, end quote. The writ of Corum Nobis originated in the English Court of Common Law, the English legal system during the 16th century, which exists in the courts we know today. The writ of Corum Nobis still exists today in a few courts in the United States. In 1907, the writ became obsolete in England and replaced by other means of correcting errors. However, the writ survives in the U.S. in its various forms in the federal courts and 16 state courts and the District of Columbia courts. For those courts with the authority to issue a writ of Corum Nobis, the rules and guidelines differ, sometimes significantly. Each state is free to operate its own Corum Nobis procedures independent of other state courts as well as the federal court system. In other words, the criteria required to issue the writ in one state or federal court system are different from the criteria required to issue the writ in the different court system. A writ can be granted only by the court where the original judgment was entered, so those seeking to correct the judgment must understand the criteria required for that specific court. That being said, all that being said, but wait, there's more. Okay, here we go. Here's what I have for you. A writ of Corum Nobis, a correcting judicial error, filing in a trial de novo. Your Honorable Chief Justices, as a pro se studying to show myself approved before the letter of the law, I am the state. As the state, I must recognize any and all wrongdoing and set it right, not as it is, as it were, but as it should be to date. We do these things because of the evil inherent nature of man, and even if there is no God, it is even more so important to obey, uphold, defend, and exercise oath in perfect adherence to the letter of the law and full color of the law. In the spirit of the law, practice good morals and stand on the higher ground in order to act in good faith and furtherance to each of our own humanity. I, Benjamin Doyle, am citing this written redress of grievances and injury. The court is open and ready to receive, wherein continues upon unfounded charges a gross miscarriage of justice and discovery of Jedburgh justice in the Kangaroo Basement Court of No Record, involving justices of the peace failing to obey, uphold, defend, and exercise in perfect adherence to the letter of the law, and as a result of felonious obstruction of justices, harmful mistakes contributing to dangerous conditions, creating hazardous situations, extenuating circumstances under duress, pressure, and stress, pro tempore, your honor, made indigent by false arrest and misprision of felony. Ex instrumentis de novo repetitoris, ex injuria jus non orator, ex dolo malo non orator actio, ex malicia sua prega diatata, ex frequenti delecto argatur poena, ex nullo facto non orator, nullo contendere, no contest. Or in other words, in layman's terms, on account of documents newly or recently discovered, illegal acts cannot create law. No right of action can have its origin in fraud. With malice afterthought, punishment is increased by the frequency of crime. No right of action arises from the contract entered into without consideration. Nullo contendere, no contest. As a result of unfounded charges as an indication of reliability, whereas any false, misleading, or inconsistent material statements in an official proceeding is a third-degree felony, all proceedings must stop and the Constitution must be taken to its end. For with any acts of impunity, justice must be served to the fullest extent of the law, whereupon discovery of any inconsistencies in all of the above, the defense no longer has to prove what statements are right or wrong, true or false. Hearsay always goes to the defendant, as no record equals no law equals private law is special counsel, and that is strictly forbidden. As such, so too, violate statute is treason, warring on the Constitution, is warring on the people. A court of record is to preserve, protect, and to keep exact copy of both true and correct on file for a period of 10 years after close. In failure to keep oath of office, let the record show where this writ, Exhibit A, was purged from the record and refused by the judge. Instead, I, the respondent, was returned the original sent in my own hand. No record, no action equals freedom from justice and null and void. Despite this, the prosecutioner's response acts with impunity contrary to the oath of office and letter of the law by knowingly and willingly proceeding with the charge, stacking unfounded charges, moving forward with sentencing. The pro tempore bench trial judge's failure to address the previously sitting judge's recusal for the plaintiff's contempt of court, failure of 3 public defenders' continuance before me to address discovery of these matters, order in the court, violation of Rule 7 upon discovery of a miscarriage of justice, any court official is required to act and act immediately and with no delay. Attorney Code of Ethics for the practice of law. Unfounded charges are a third-degree felony. Moving forward with no record equals no action. It is a felony of a third degree, even for a judge. Judicial Code of Ethics, Your Honorable Chief Justice. Ignorance of the law is not a defense in the courtroom. A pro se has the absolute power and authority and political immunity of the state and cannot make a mistake in law nor be arrested while practicing at bar. It is the judicial officer's responsibility to address, note it, and correct any mistake in law and proceed as though it never happened. Discovery is not a shell game. Honorable Judge Ritter, 1956. As it is any court official's obligation to responsibility to act and act immediately, discover any miscarriage of justice. No record equals no cause. No law equals private law. Special counsel is strictly forbidden. Strictly forbidden is strictly forbidden, as it violates statute. Your Honor, this is not the first judge whom violated a controlling statute. How are you going to resolve this blatant disregard for malpractice in the letter of the law? I, for one, vote one for all. No confidence. Thank y'all. Just practicing speech at a lectern in the library as best I know how. Use the force. May the force be with you always. And that, as they say, is that. The rest is history. Study history or be forced to repeat yours. I don't know. I just got turned on to it by reading an article in the Atlantic about the post-Civil War Reconstruction era and the judicial system in the courts. It seems more information is since coming to light about history's mysteries and the actual real history of the U.S. and what's brought us to here henceforth today. Okay. Watch. Listen. Learn. Find out for yourself. Just be sure to pick up the phone and call a friend, because you might not be getting the same information here as they are there. Anyhow, that's just me. We'll see. Thanks. Bye. All for one and one for all. Yo, bro. Later on, though. Take it easy. Goodbye.